A unanimous 9-0 ruling has just been issued, and here is the aspect nobody is explaining directly. Depending on whether you comprehend what this decision actually means, it either just provided law enforcement a authority over you that they did not possess previously, or it provided you the most powerful legal protection a firearm owner has ever possessed during a traffic stop. The difference between those two results comes down completely to what you know entering into the next interaction. If you carry a firearm in your car legally with a permit, doing everything correctly, this ruling modifies the rules of every traffic stop you will ever experience for the rest of your life. I have been discussing firearm law for years, and I can count on one hand the number of decisions that have impacted this strongly for ordinary firearm owners. I am going to explain exactly what the court determined and why it is important. I will guide you through what this ruling safeguards, and then, more importantly, what it does not safeguard you from, because that is where the risks are hidden. I will provide you the exact 5 words that defense attorneys suggest you memorize for every traffic stop. I will provide you a script for what to do if an officer searches your car anyway, even after you have asserted your rights. And I will provide you the practical playbook for the moment those lights show up in your rearview mirror. Before we proceed any further, click that subscribe button right now. Firearm laws change quickly. Court decisions like this one arrive without notice, and the people who suffer are always the ones who did not know. Subscribe, turn on notifications, and let us dive into this. Let me establish the scene for you because this case did not begin in the halls of the Supreme Court. It began the way most landmark decisions do, with something that appeared completely ordinary. The case is Commonwealth v. Robinson out of Massachusetts. Now, I know that might not seem relevant to you if you live in Texas or Florida or Ohio. Hold on. Because when a state Supreme Court issues a ruling this powerful, unanimous, based directly in the Fourth Amendment, federal courts take notice. Defense attorneys in other states start referencing it immediately, and the constitutional principles that drove this decision apply to every driver in every state in America. Here is what occurred. Shortly after midnight, a driver is pulled over on a routine stop. The reason? A window tint violation. That is it. Not speeding, not reckless driving, not any kind of threatening behavior, just windows that were allegedly too dark. During the stop, the trooper notices a few things. He says he smells unburnt marijuana, not smoke, just the odor of raw weed. He observes the passenger has 2 cell phones, including what he describes as a burner phone. And he notes that both the driver and passenger have matching hand tattoos that he associates based on his training with possible gang affiliation. Here is what happens next. The trooper removes the passenger from the car, frisks him, and handcuffs him. They run his information. He has an old warrant, a 2014 shoplifting charge. So, the passenger is now secured in the back of a cruiser. 3 troopers are on scene, 1 driver. The situation is completely under control. And then the trooper orders the driver out of the vehicle. Now, here is the part that made this case blow up. When the trooper was asked in court why he issued that exit order, he testified that he ordered the driver out specifically so he could, and I want you to hear this, ask for permission to search the car. He admitted on the stand that there was no safety threat. The driver was described by the troopers themselves as very respectful, very cooperative, and pretty chill. He was not reaching for anything. He was not threatening anyone. 3 troopers, 1 cooperative driver, and still the officer used the exit order as a tool to get to his real goal, consent. Within 2 minutes of stepping out of the vehicle, the driver said something like, "Yeah, you can take a look around." The trooper searched. In the center console, he found cocaine and fentanyl. In a locked glove compartment, he found a ghost gun with a loaded extended magazine. The driver was arrested and charged with firearm possession, ammunition possession without a license, and drug trafficking. He was looking at serious federal prison time. His attorney did something smart. He did not just fight the charges on their face. He went back to the very beginning and said, the exit order was illegal. And because the exit order was illegal, everything that came after it, including the driver's consent to search, is tainted. It is fruit of the poisonous tree. The prosecution pushed back hard. They argued that consent was consent. That he said yes, that what happened before the yes did not matter. The lower court sided with the prosecution. The conviction stood, and then the Massachusetts Supreme Judicial Court, that state's highest court, took it up. On a unanimous 9-0 vote, they threw the whole thing out. Their reasoning was direct and hard to argue with. Under the Fourth Amendment, police cannot order you out of your vehicle during a traffic stop unless they have one of three specific things: articulable officer safety concerns, reasonable suspicion that you are engaged in criminal activity, or independent grounds to search the vehicle. In this case, the Commonwealth admitted in oral arguments that none of those applied. The driver was calm, cooperative, and posed no threat. The passenger was already handcuffed and locked away. There was no basis for the exit order, which means the exit order was an illegal act. But here is where the court went even further, and this is where it gets critical for you as a firearm owner. The prosecution still had their backup argument. The driver consented. He said, "Yes." Does that not clean everything up? The court said no, and here is why. Consent is not automatically valid just because someone says the word. When that consent comes immediately after an illegal police action, it is considered tainted. It is the fruit of the poisonous tree. The court laid out three factors for determining whether consent is actually valid after illegal conduct. First, temporal proximity. How much time passed between the illegal act and the consent? Here it was less than 2 minutes. That is not enough time for the coercive atmosphere to lift. The driver stepped out under an unlawful order and within 2 minutes was agreeing to a search. The illegality and the consent were essentially the same moment. Second, intervening circumstances. Did anything happen between the illegal exit order and the consent that could break the chain? Was the driver told he had the right to refuse? Was he read his rights? Was there any meaningful pause? Any shift in the environment that gave him the freedom to make a genuinely voluntary choice? Nothing. The coercive situation never lifted. Third, the purpose and flagrancy of the misconduct. This is the one that matters most for your understanding of what police are trained to do and what they will sometimes try. The trooper admitted he used the exit order as a deliberate tool to get to the consent request. He knew he did not have probable cause. He knew he did not have reasonable suspicion. So, he manufactured a reason to get the driver out of the car, knowing that once the driver was standing on the side of the road with 3 officers around him, saying yes would be a much easier path than saying no. The court called that exactly what it was, the exploitation of a constitutional violation. Based on all 3 of those factors, the consent was ruled invalid. The search was illegal, and all of the evidence, the drugs, the gun, the ammunition was suppressed. The drug trafficking charges were dismissed. The ammunition charge was dismissed with prejudice, meaning the prosecution cannot refile it ever. Not because the items were legal, but because the state violated the Constitution to find them. That man was facing years in federal prison. And because one court said the exit order was illegal, the entire case collapsed. Now, let me pull out to the broader ruling and what it means for you directly as a firearm owner. The court did not just rule on exit orders and tainted consent. They also addressed something that has been eroding the rights of firearm owners for years in traffic stops across this country. For a long time, some police departments operated under the theory that a firearm in a vehicle automatically elevated the risk level of a stop, that it gave officers justification to be more aggressive, to issue exit orders, to pat down compartments, to search. The logic was essentially, guns are dangerous, officers need to be safe. So, the presence of a gun gives us broad authority to act. The Supreme Court shut that down completely. Their ruling was crystal clear. You cannot treat the exercise of a constitutional right as evidence of criminal conduct. Legal gun ownership is not probable cause. It is not reasonable suspicion. It is not a safety threat in itself. If you are a lawful gun owner, permit valid firearm legal in your state. No prohibited status. The presence of that gun does not strip you of your Fourth Amendment rights. The court also addressed the automobile exception directly. This is the legal doctrine that allows police to search a vehicle without a warrant if they have probable cause to believe it contains evidence of a crime. Courts created this exception because cars are mobile. Evidence can disappear before a warrant is obtained. That doctrine is still valid. The court did not eliminate it, but they put a firm limit on how it can be used. The automobile exception requires probable cause of actual criminal activity. Owning a gun legally is not criminal activity. Carrying a gun with a valid permit is not criminal activity. Therefore, a gun alone cannot trigger that exception. To use the automobile exception, an officer needs evidence of something that is actually a crime, not evidence of a constitutional right. Think about what that means in plain English. You cannot be punished through the loss of your Fourth Amendment privacy simply for exercising a right the Constitution explicitly guarantees. That is what the court ruled unanimously with every justice in agreement. Now, I need you to pay very close attention to what comes next, because this is the part that almost every channel covering this ruling either glosses over or skips entirely. Most of the coverage on this ruling stops at great news for gun owners, and it is great news. But stopping there could get you into more trouble than you were in before because this ruling has very specific limits. And if you do not understand them, you can walk out of a video like this feeling invincible, and invincible is the wrong feeling. Informed is the right feeling. There's a huge difference. The court was precise in their language. The ruling said that a legal firearm by itself, alone, without other factors, is not sufficient justification for a warrantless search or an unlawful exit order. That word alone is doing an enormous amount of work in this ruling, and here is why. The court specifically left room for what legal experts call additional articulable facts. That is a legal phrase for other specific things an officer can point to beyond just the gun. That together could add up to probable cause or reasonable suspicion. Let me walk you through the scenarios where an officer can still legally act even after this ruling, because you need to know these before your next traffic stop. Scenario 1. Your record comes back with a problem. The officer runs your information and it shows a prior felony conviction. That makes you a prohibited person, someone legally barred from owning or carrying a firearm under federal law. At that point, the gun in your car is not just a gun. It is potentially a federal crime. That is probable cause. This ruling does nothing for you in that situation. It only protects lawful gun ownership in lawful circumstances. Clean record is part of the shield. A dirty record punches a hole right through it. Scenario 2. Permit issues and state lines. Concealed carry permits are not universally recognized. Some states have reciprocity agreements that honor each other's permits. Others do not. If you drove across a state line and you are now in a state that does not recognize your home state's permit, you could be committing a crime without knowing it. This ruling does not save you from that. It only protects legal carry. If your carry is not legal in that jurisdiction, the protection evaporates. Before you drive through any state with a firearm, look up that state's current reciprocity laws. Not what a friend told you, not what you remember from 2 years ago, the actual current law. Scenario 3. The totality of circumstances. Let us say you are pulled over in an area known for criminal activity. You have a firearm and the officer notices other things. Maybe there is drug paraphernalia visible on the seat. Maybe you are reaching around under the dashboard. Maybe your behavior is what courts describe as furtive movement. Each one of those things alone might not be enough, but stacked together with the gun, an officer can argue he had the totality of circumstances needed for reasonable suspicion or probable cause. That argument is still fully valid after this ruling. A legal firearm combined with other red flags is a very different legal situation than a legal firearm by itself. Scenario 4. Plain view doctrine. If an officer looks into your vehicle and sees something that itself suggests criminal activity, not the gun, but something else, they can use that as justification for a search. The gun becomes part of a larger picture, not the cause of the search. The ruling does not block that. It only blocks the gun being used as the sole basis for suspicion. Scenario 5. Illegal storage or configuration. Different states classify firearms in vehicles very differently. Some require the gun to be unloaded. Some require it to be stored in a locked container. Some have rules about where in the vehicle a loaded firearm can be kept. A firearm that is legal in a general sense can still be illegally stored under your specific state's law. If an officer can see that your firearm is in a configuration that violates state law, the ruling does not protect you because the possession itself is illegal in that circumstance. Here is the underlying truth of all 5 of those scenarios. This ruling is a shield for people who are doing everything right: legal firearm, valid permit, clean record, proper storage, correct jurisdiction. If all of those boxes are checked, this ruling is a massive protection. But if any one of those boxes is not checked, the shield has holes, and you need to know exactly where those holes are before you ever get pulled over. Now, let us talk about what you actually say and do during a traffic stop, because the ruling is only as powerful as your ability to invoke it correctly in the moment. There are 5 words every gun owner needs to have memorized right now, not when you get pulled over. Right now, those 5 words are, "I do not consent to searches." That is it. 5 words: respectful, calm, clear, and completely non-confrontational. Let me be precise about what those 5 words do and what they do not do. They do not stop an officer from searching if he already has genuine probable cause. If he smells marijuana, if there are drugs visible, if he has a warrant, he can search regardless of what you say. Your words are not a magic barrier, but if he does not have probable cause, if he is just asking, just hoping you will say yes, just fishing, those 5 words change everything. They create a record. They establish that any search happening after that point is happening against your will without your consent. And that record is exactly what your attorney needs to file a motion to suppress the evidence in court. In the Robinson case, the driver did not say those words. He said something like, "Yeah, you can take a look." And the only reason the court saved him was because the exit order that preceded that consent was illegal. If the exit order had been lawful, if there had been a genuine safety concern, that consent would have sealed his fate. There would have been no legal argument to make. The 5 words are your protection against that scenario. They preserve your ability to fight later in court, where the fight can actually be won. Now, I want to tell you something that a lot of gun owners get wrong about this. A lot of people hear about a ruling like this and think, "Great, I will just invoke my rights at the car window. I will explain that the search is unconstitutional." Do not do that. Defense attorneys are unanimous on this point. Citing case law to a police officer at the scene almost never helps and very often makes things significantly worse. The officer is not a judge. He cannot rule on the constitutionality of his own actions in real time. The legal argument belongs in a courtroom. At the car window, you are calm, cooperative, and you say 5 words. You are not submitting. You are creating the record that wins the argument later. And here's the psychology underneath all of this. When officers ask for consent to search, they are asking specifically because they do not have probable cause. If they had probable cause, they would not need your permission. The request itself is the tell. When an officer says, "You don't have anything illegal in there. Do you mind if I take a quick look?" What he is actually communicating is, "I don't have enough to search without your help." Most people trying to show they have nothing to hide say yes. And in that moment, they hand over the one protection that was specifically built for exactly this situation. "I have nothing to hide" sounds reasonable, but it means your privacy rights only exist when you have done something wrong. The Fourth Amendment exists precisely to protect innocent people from the government digging through their lives. You are not refusing to cooperate by declining a consent search. You are exercising a right that 200 years of American law says you have. Now, here is the scenario that most people do not have a plan for because they assume the 5 words end the encounter. Sometimes they do not. Sometimes an officer decides to search anyway. And if that happens to you, you need a specific 3-step plan. Step 1 is the statement. The moment the officer begins to search and the moment they reach for a door handle, open a compartment, lean into your vehicle, you say this out loud, calmly and clearly. "Officer, I do not consent to this search. I am not giving you permission. I am complying under protest." Say it clearly enough to be picked up by any body camera or dash camera. This does 2 things. It creates an unambiguous record that you did not consent, and it shows that you are compliant, not resistant, which closes the door on any obstruction charge. Step 2 is observation. While the search is happening, you do not argue. You do not interfere physically. You do not attempt to stop them. What you do is watch. Watch what they touch. Watch what they open. Watch what they find and where they find it. Note the sequence of events as carefully as you can. That specific detail in what was found, in what location, in what order is the raw material your attorney needs to build a suppression argument. Generalities do not win suppression motions. Specifics do. Step 3 is documentation. The moment the stop ends, whether you are released or arrested, you write down everything you can remember. The officer's name and badge number, the time and location of the stop, the reason given for pulling you over, what the officer said about why he was searching, what was said in order to the best of your memory, what was found and where. If you are arrested, do not talk about the case to anyone except your attorney. Not friends, not family on a recorded jail call, not anyone. The first thing you tell your attorney is this: I did not consent to the search. I said it clearly. It should be on any recording. Now, let me give you the real-world playbook for the moment those lights appear in your rearview mirror. Hands visible immediately. Before the officer reaches your window, your hands are on the steering wheel at 10 and 2, not moving. If it is dark, turn on your interior dome light. This removes every reason for an officer to be afraid, which removes every reason for the encounter to escalate. Do not reach for anything until instructed. Not your registration, not your insurance, nothing. Wait for the officer to ask. If your registration is in the glove box and your firearm is also in the glove box, tell them that before you open it. Officer, my registration is in the glove box and my firearm is also in the glove box. How would you like me to proceed? That one sentence prevents a dangerous misunderstanding. Know your state's disclosure law before this ever happens. Some states require you to proactively tell an officer about a firearm the moment you are pulled over. Others do not require it, but recommend it. You need to know your state's rule before you need it, not while you are sitting on the side of the road trying to remember. If your state requires disclosure, do it calmly and early. Officer, I have a concealed carry permit, and there is a firearm in the vehicle secured in the center console. If asked to consent to a search, invoke your 5 words politely, clearly, once. You are not being hostile. You are exercising a right. The officer may still search if he concludes he has probable cause, but your refusal is on record. If the officer searches anyway, do not physically resist under any circumstances. Say clearly out loud, I do not consent to this search. I am complying under protest. And then let it happen. Physical resistance turns a potentially winnable legal case into additional charges. The legal remedy for an unconstitutional search is in a courtroom, not on the shoulder of a highway. Document everything the moment the stop ends. Officer's name and badge number, time and location, what was said, what was searched, what was found, what reason was given. Write it all down immediately. Call an attorney before saying another word to anyone about the substance of what happened. If you are arrested or believe a serious violation occurred, your next conversation about the details is with a licensed attorney in your jurisdiction, not friends, not family on a recorded call, an attorney. Before I wrap up, let me go over the 5 most common mistakes gun owners make when they hear a ruling like this one. Because the wrong takeaway here can hurt you just as badly as not knowing the ruling at all. Mistake 1, thinking this ruling protects you when the facts are bad. It does not. Prohibited status, active warrants, other illegal items in the car. This ruling does nothing for any of those situations. It protects lawful gun ownership in lawful circumstances only. Mistake 2, arguing case law at the car window. The car window is not a courtroom. Invoke your rights with 5 words and save the legal argument for where it can actually accomplish something. Mistake 3, assuming your permit works across state lines. It may not. Verify current reciprocity laws for every state you plan to drive through. This is a 5-minute search that can keep you out of federal prison. Mistake 4, not knowing your state's storage and transport laws. A legally owned firearm can still be in an illegal configuration depending on your state, how it is stored, whether it is loaded, and where in the vehicle it sits. Know the specific rules wherever you drive, not just your home state. Mistake 5. Thinking one ruling ends the fight. It does not. Gun rights are won through constant legal battles and constant education. This unanimous ruling is a landmark victory. Celebrate it, understand it, and use it. But stay engaged because the legal landscape around gun rights changes continuously. Let me pull this together for you. The court ruled unanimously that a legally owned firearm in your vehicle does not by itself give police the authority to conduct a warrantless search or issue an unlawful exit order. Your Second Amendment right and your Fourth Amendment right exist simultaneously and completely. You do not have to choose between them. Exercising one constitutional right cannot be used as justification to strip you of another. That is not a close call. That is every single justice agreeing on one answer. This ruling is strongest for gun owners who are doing everything right. Legal firearm, valid permit, clean record, proper storage, correct jurisdiction. If that is you, this ruling is the most powerful legal protection that has ever been put into writing for your rights during a traffic stop. This ruling has limits: prohibited status, permit issues across state lines, other evidence of criminal activity, illegal storage configurations. All of these can still give officers justification to act. Know the limits. Do not let the victory make you careless. In any traffic stop with a firearm in the vehicle, your behavior matters as much as the law. Hands visible. Stay calm. Disclose if required. Invoke your 5 words if asked for consent. Never resist physically. Document everything afterward. Call an attorney if needed. And the bigger principle underneath all of this is worth stating plainly. The Supreme Court just put into writing something that should have always been obvious. In America, exercising your constitutional rights cannot be weaponized against you. Doing something the Constitution protects cannot be treated as evidence that you are a criminal. That is a statement worth understanding, worth protecting, and worth passing on to every gun owner you know. Everything you heard today is educational information designed to help you understand your rights. It is not legal advice for your specific circumstances. Laws vary by state. Situations vary by facts. And if you ever face a real legal issue involving firearms, traffic stops, or search and seizure, please consult a qualified attorney in your jurisdiction. Stay safe. Stay legal.